Hi, this is Brad Wiewel, and we are here with the Estate of the Union, our fantastic podcast on estate planning, and we have a fantastic guest today. So this is a fantastic day. We have a fantastic guest, a fantastic topic. She's fantastic. I think I'm pretty fantastic, at least who thinks I'm fantastic? And it's a little, kind of a short list of people who think I'm fantastic.
I think you're fantastic.
Thank you, Ann. God bless you. This is Ann Lumley. I'm Brad Wiewel. We're here with the Wiewel Law Firm in Austin, Texas, and we have our podcast, The Estate of the Union, that we do frequently to educate you about estate planning. There's lots and lots and lots of things to know about estate planning. We're not going to try to make you an expert. We do want to make you informed. There's a theory out there that there are two legal systems in the country. There's a legal system for the informed, and there's a legal system for the uninformed. And so what we're trying to do here with the Estate of the Union is educate you and move you into the realm of the informed. Now, one of the areas of estate planning that I think is the most mysterious is probate. And everybody's heard you should avoid probate, and everybody maybe aspires to do that, but frankly, 99% of the people couldn't tell you what probate is and really couldn't tell you exactly why you should avoid it. So we have an expert here. We have Ann Lumley. And Ann Lumley is our Director of Estate Administration at the Wiewel Law Firm and has handled hundreds of probates and these things called living trust administrations, which come into play if you die with a living trust instead of a will. Ann is going to take the time today to walk you through things you need to know about probate, and if we don't finish it all today, we'll come back and do it again.
Sounds good.
All right, great, Ann. Well, thanks for coming. And Ann has helped write a book called Surviving Texas Probate, and this is an excellent short, really, how long is this book? 66 pages, including the glossary. And you can download this book off of texastrustlaw.com, texastrustlaw.com. Go to our homepage. It says download our books. This book is right there. Download the 66 pages, and you'll know more about this. You can also get off of Amazon the Surviving Texas Probate book. And for our audience, what the heck is probate?
Well, that's a good question, Brad. Let me start by saying estate administration is what you do when someone dies, and probate is the process of going through court. So every estate administration doesn't necessarily involve a probate, but you have to look, I tell people when they come in to see me, you have to look at each asset. It's a process of retitling, and you have to look at each asset and see how it's titled to see, I call it what rule book is going to apply. And so you have probate assets and you have non-probate assets.
Okay.
Non-probate assets would be assets that are titled like in a trust, or accounts that have a pay-on-death designation or a named beneficiary like life insurance. Those type of assets, the rule book is going to be the trust for the trust assets, okay, and the accounts for those other types of assets. Joint accounts with right of survivorship are also non-probate assets.
What about retirement accounts?
Well, the intent is for it to be a non-probate asset.
Okay, all right.
And so if there's a proper beneficiary designation, it'll pass directly to that beneficiary outside of court. But sometimes people fail to make beneficiary designations, or the people that they've named may have predeceased them, and it ends up with no beneficiary designation. And it's going to be up to each policy what happens, but often the default is it goes to the estate, so it becomes a probate asset.
Okay, so back to, again, our audience. What is probate?
Probate is the process of going to court and getting authority to access these probate assets and get them to where they're supposed to go. When there's a will, it'll go according to the will. That's the rule book. Okay. If there's no will, then it goes by Texas intestacy law, which can be a bit of a surprise for people because it doesn't always go where they want it to under intestacy law.
Now, some of our listeners may live in other states. Does each state have its own intestacy law?
Yes, that's correct. So intestacy is only good if you go to court and you have a will, you can probate another state's will in Texas. It might not be ideal because Texas wants to see magic words in their will, but it's possible to do that because of the full faith and credit laws. But because each state has its own rules for intestacy, you can only probate with intestacy in that state for assets located in that state.
Okay, let me see if I can make this potentially a little bit clearer. If I die and I live in Texas and I have a home in Colorado. Texans love Colorado. Holy cow, they love Colorado. And if I die and my home in Colorado is in my name and I don't have a will. So intestacy means I die without a will. Do I go through intestacy? Do I go through court here or there or both?
It depends.
Now, let me
If you
say,
have real estate in both states, you're going to have to do it in both states.
all right, ladies and gentlemen, Ann is an experienced lawyer. That's the most favorite line that lawyers have. It depends. And you said it so well, and I was
I say it a lot.
very impressed with it. Thank you, Ann. All right, so tell me about that 2 states. Now, that's 2 lawyers, I presume, or
Yes.
more?
So here's the thing. If you have a California will and you have real estate in California and in Texas, you can choose which state has better probate rules, and you can probate in one of those states and do what's called an ancillary probate, where the other state will recognize the probate in the state where you actually went to court. But when you have intestacy laws,
Again, that means dying without a will.
there's no will, so you're stuck with the state's rules on where it goes. Since each state could have varying rules, you're not able to do that. So you'd have to definitely do a full-blown administration in each state to take care of that real property.
Wow. Wow. And so the Texas law says where it goes when I die without a will. Could Colorado say that property maybe goes a different direction to different people?
Yes, for sure.
Huh.
Texas recognizes what we call laughing heirs, and so it can end up going to really remote relatives that don't even know the person that's passed away. I have a case right now that went to people that had never heard of the decedent, and it's very challenging to get people to agree to sign waivers or to even acknowledge there's a court process. If they don't know who this person is, they tend to ignore the document you send them, even if you're telling them they're going to inherit something.
Well, couldn't they think it's a scam?
Yes, and so it can be very challenging when you have heirs that spread out, go that far. Not all states go that far down the airship
The
line.
rabbit trail. But some states, I think, Ann, that don't go that far. So Texas and other states, I'm sure, if you've got somebody with a fleck of DNA and we can find out who that person is, that person would inherit the estate because they're the closest relative to the deceased. But other states, it seems like, Ann, would send that after a certain point to the state.
And that's true.
And that's called cheat, I think, right?
Yes.
And that means cheat.
They cheat you out of your money.
They cheat you out of your money, ladies and gentlemen. So, all right. So I want to stay on this dual state thing for just another minute. We're going to move on to other topics. This is so good. But I die in Texas. I die in California. I die in Connecticut. I've got no will, and I've got real estate in both states. I have to do 2 full-blown intestacy airships, I think is what we call here in Texas, to see where it goes, and it will go perhaps to different people depending on the laws of Connecticut versus the laws of Texas.
Correct. Texas, we call it an airship determination, and the court officially determines who your legal heirs are. And so the property in Texas will go according to the Texas airship determination, but the heirs might be different in another state. So the property in that state will pass according to their rules.
Whew. Well, it sounds like everybody needs a will.
It's complicated. Yes. I think that, yes. You've asked me before what's the worst thing, and you could say dying without a will, but sometimes people mess up their wills when they try to do them themselves. So that's why I paused. I was like, the worst thing, it's not good, but sometimes it's worse when you try to do it yourself.
Well, let's talk about that, because the case that you mentioned where you have heirs out there that didn't even know the dead person existed. Holy cow. I'm a little familiar with that case because it's here in our law firm. Was that a homemade will that somebody tried, or how did that come about?
So in this particular case, our client was trying to help a friend that was having health issues. She had capacity, but she just needed some assistance.
Capacity means she had enough brain power to know what she was
Yes,
doing.
she knew what was going on, and she wanted to do a will. So this person copied her own will and tried to put the information in, and she was able to name an executor, and that's the person that can administer the estate. But she failed to mention where the property goes to. The whole, what we call a disposition clause, was missing. So we had, it was properly executed. It was signed by the testator. It was witnessed by 2 people.
Right.
It was self-proved. It had the notary and all of the self-proving affidavit language.
We'll talk about self-proving here in a minute, because I'm sure a lot of our listeners have no idea what that is. We'll come back to that. All right.
But so we had to admit the will because it existed, but the will contained a complete intestacy, so we also had to do a determination of heirs.
So the will didn't say who got it.
No, it just said that I named this person to administer my estate, but it didn't mention what to do with the property.
Okay.
And so we had to go to court to find out who the heirs were, because this person that passed away had no children, she had no siblings, both of her parents had predeceased her, and we had to hire a private investigator to find what turned out to be about 50 living heirs scattered across the country.
Wow.
And it took an entire year to get waivers of notice or to get people personally served so that we could even have the hearing to determine the heirs in the first place.
Wow.
And there wasn't that much in the estate, and it's still going on. It's been going on for several years because it's just a lot more complicated, trying, like I said, to get people to respond properly to move things along.
And so this little lady had gone to a lawyer who is familiar with doing wills and had done a will with the lawyer. This could have all been avoided.
Yes, if her friend had seen an attorney. I've seen lots of things like that. I've seen people copy their neighbors' wills, but they forgot to change the executors. Like they were able to change the names, so the husband and wife were leaving things to each other, but they forgot to change who the executors were named. And they're like, who's this person? And they're like, I don't know who this person is. And I'm like, well, that's who you've named to administer your, yes. And you have to use the people named and the order named when you probate a will. They have to either you have to prove they predeceased, or they have to sign something where it's a waiver and renunciation of right to letters testamentary, where they choose not to be the executor.
Okay.
So they were stuck with these people they didn't know how to contact, and they would all have to decline to serve in order for something else to happen.
Wow. And the sound you hear in the background, ladies and gentlemen, is cha-ching, cha-ching, cha-ching. These are very, very expensive, complex, time-consuming operations, all because somebody either died without a will or didn't go to an attorney, we would say an experienced estate planning attorney, to get it done right. Now, Ann, since we're on this topic, we're going to go into another very popular way that people do their wills these days, because people know and they need a will. And I've heard that if you die without a will, certain things will happen. That's not good. So I'm smart. I'm mature. I'm going to take care of my family. I'm going to do a will online. Okay? And let's talk about online wills and your experience with those.
Well, Texas has some magic words. I kind of talked about it
You did
earlier.
mention that.
But in Texas, there's 2 types of administrations when you probate. You can either have an independent administration or a dependent administration. Independent, you go to court once. I maybe ask about 12 questions to do what's called proving up the will to get it admitted, and then letters testamentary are issued to the executor. It's literally a piece of paper that say letters testamentary on it, and that's their license so that they can access the probate assets that may have been frozen and administer the estate. But that's
So this is kind of a permission slip.
Yes, but that's the only court involvement. There's one hearing. When you have a dependent administration, it's court supervised. So everything that you want to do, you have to ask the court permission for. If you want to pay a bill, you need to make sure that you can pay a bill. There are a few things that you can do without permission, like paying your bond.
But you have to get a bond.
You have to get a bond in a dependent administration. So the administrator or executor in a dependent administration has to put up money to be insured to make sure that they're not going to
Steal the money.
steal from the estate.
All right. But let's get back to software wills.
So software wills don't always have the magic words that we want to see in
To get an
Texas,
independent
To get an
administration.
independent administration. It's common that that's not always in there. Sometimes you can get around it if there's no one's contesting it. If all the people that are going to take under the will are in agreement, they can decide to have an independent administration. They have to consent in writing, and they can pick the person that they want to serve independently. But if there's minors that are going to take, or if there's any discord in the family or
Maybe a
amongst
handicapped person.
the beneficiaries, or then you can't have the independent administration. You end up with a dependent, which is much more complicated and expensive.
Okay, now that's the will itself. I've heard you many times say that the problem with the software will isn't something that you may be able to fix, but because of the way it was signed, it's a problem. And let's talk about that. When I'm sure these software companies try to give the people who do the $35 will some instructions, but what have you found on that?
Well, I had one that had done an online will program, and they had taken it to like a mailbox, et cetera, place to get notarized. And unfortunately, the witnesses filled in their information, and they put a different date that was after the date that the notary had dated, and so that made it an invalid will.
Wow.
It wasn't self-proved, but it just didn't make sense because they said they were there, and the witness has to sign in the presence of the testator. There's just different things that have to happen that just missing the date messed it all up.
So if you die with a will that you think is your will, but for some reason you didn't get it signed correctly, it's an invalid will.
Yes, the whole execution process is important. So when you
Execution means the signing
the
process.
signing of the will, making sure it's done in the correct way.
So, ladies and gentlemen, if you get an online will, which we don't recommend, but if you do that, the key is making sure you get the right program, and you're never going to be sure. And the people behind the company that you're getting it from may not be sure, because we see mistakes all the time, but it's really in the way that it's signed that makes a huge difference, because if it's not signed correctly, and you said it's an invalid will, which means I died without a will.
Exactly.
But I thought I had one.
But it wasn't done properly.
Which
and
is-
not properly is not a will.
I think that's the worst thing that can happen. I think the worst thing that can happen is you think you have a will and you don't. If I don't have a will, I know I don't have a will. And I know consciously I don't have one, I need to get one. But if I've got one, that I have now a nice warm feeling in my tummy that I've done this will, but I screwed it up, or the company I bought it from somehow screwed it up, and it's not valid, then I didn't have it. And again, that seems like the biggest tragedy, because you really tried to do something and you dropped the ball. I feel like it's the running back who gets to the goal line and wants to spike it and spikes it right before the goal line, and he doesn't score a touchdown.
That's right. You almost made it, but not quite. And I've seen that a lot as well. I've seen other attorneys that don't practice in this area draft wills for family members or other people, but they didn't think about some of the contingencies that we as estate planning attorneys build into our documents. We always have provisions so that if somebody is actually a minor that takes, because you might plan on giving something to a child of yours that is an adult, but they might predecease you, and then it goes to some of their children, and they might be minors. And so we have provisions that they can receive it in a trust, because minors can't own property.
Right.
So you can avoid a guardianship by having that in there. Or you never know what's going to happen. That's something I've learned in my job. I look at death certificates every day, and you just never know. And so sometimes one of your beneficiaries who's perfectly healthy when you are writing your will might be in an accident and become dependent on government assistance for special needs. And
Right.
so they need to be able to receive their inheritance in a special needs trust, so they don't lose their government benefits. And so not all wills have these provisions, these backups, safety nets built into them.
And it can be a disaster. And let's get back to an invalid will, you thought you had when you didn't, or you don't. And if you've got minor kids and you don't specify the guardians, or you screw up your will and it's not valid, then that whole issue is up in the air too. And what Ann just said about minors receiving money. Minors can't own anything. You can't put your car in the name of your 16-year-old daughter because she's not an adult, and the law says she can't own property. If she inherits property, Ann, and she gets it either because her loved one that left it to her didn't have a will, her dad died, didn't have a will, she got the $100,000 bank account, what does she do? What happens to that money? If she's a minor, if she can't use it, what happens to it?
Well, she may end up with a guardian of her estate to manage property.
And
if
that's
it's under
court.
That's court, and that's not cheap.
Right, and then she gets it all at 18.
Right, which could be
Problematic.
they might not have the best judgment at that age with a windfall of
You strike me
money.
as a very mature person at 18, and I was not a externally mature person at 18. And had I received $100,000 at 18, and this would be, I hate to say this, 1970, at $100,000 in 1970 is a lot more money than $100,000 today. I'm not sure I would be alive talking to you right now, ladies and gentlemen. So a will has many things to it. We're going to come back to Ann in future podcasts and get more depth on things like minors and more depth on things like dying without wills and the magic words she's talking about and all that. But we have a little more time here. I want to go back to something we brought up earlier in the program, and it was a term that Ann used, and it's an important term, and the term was self-proved. And I said, we come back and talk about it, Ann, because you said, well, the will wasn't self-proved. What does that mean? If our audience has a will, how do they know if it's self-proved or not?
There's special wording that needs to be included, and Texas does allow what we call a one-step process. What most people would be familiar with, perhaps, is that the testator and the two witnesses sign the will, and
The
that makes
testator
it
is the person creating
the person
the will.
that is and that
Okay.
and when you're working for probate, the person that passed away, the
Right.
person that wrote the will, signs it with the witnesses, and that makes it a valid will. What makes it self-proved is a separate attestation clause, and that just gets the facts on the record for the court. A notary has to witness the witnesses signing this, but it states that the testator was of the correct age, that the witnesses were over 14, the testator was of sound mind. The things that need to make a valid will, they're saying that at that circumstance this happened, and the notary kind of makes it official. So when that's included in a will, it can be in a separate paragraph, or Texas does allow what we call a one-step process, so all before everyone signs. If that's in there, you don't have to have people come to court to get that information on the record. It's considered self-proved, so you don't need additional witness testimony.
So if I've got a will and I've done it on my own, there's an excellent chance it won't be self-proved. I go to a notary. Do I even need a notary for having a valid will?
No.
All right.
You need two witnesses.
All right.
But if one of your witness signature fails and there is a notary, then the notary can count as one of the witnesses.
All right. But what I don't want to have happen, what you don't want to happen, ladies and gentlemen, is finally mom dies, finally dad dies, they've got their own will that they went to, a software program to get, they borrowed their neighbors, they hand wrote it out, and we'll talk about handwritten wills at some point too. But they don't have this thing called a self-proving affidavit that says, again, they were 18 and up, they were of sound mind, that there were witnesses, two witnesses. Again, in Texas, some states say three witnesses, that the witnesses were over the right age. And in Texas, the right age, you can have a witness 14 years of age and older. That's all set out in that special little paragraph. And then it's notarized. The notary puts everybody on oath and says, are you swearing this is true? And everybody says, yeah, this is true. Then when grandpa dies, you don't need to bring the witnesses into court to prove that because they've already proved it with the special document. Is that right?
That's correct.
And that saves a lot of time.
Yes, and it can be hard to find witnesses. When
Sure.
you've done a will 20 years earlier, you've lived in a different state. So sometimes you can't find the witnesses. The first choice is to get one of the witnesses or the notary to testify because they were there and it's firsthand knowledge. But if you can't do that, Texas allows you to find 2 people that don't take anything under the will that will testify that that indeed was the testator's handwriting on the signature, and that at that time, to the best of their knowledge, he or she was of sound mind. So you can get it in. I always tell people there's usually a way around things, but like you said, it's usually a lot more complicated. It involves legal expenses, and it's just a lot more expensive in time
Right.
and money.
So don't try this at home. We have about 5 minutes left. Let's go to something that I just touched on that people are always curious about. Can I do a handwritten will? Now, some states don't allow handwritten wills. Most states don't, I think, but Texas does. So tell us about a handwritten will.
Texas will recognize a handwritten will if it's all in the testator's handwriting, the entire will. It can't be typewritten by the testator and then signed. It has to be entirely in the handwriting. It needs to show that it is intended to be a will, that there's testamentary intent. It does not have to be witnessed. It just has to be signed by the testator in the handwriting. So Texas does recognize them, but they can create many problems as well that we've touched on. Missing the magic words, missing they might not even name an executor. Certainly probably not independent if they do. They don't have those contingencies for if there's a special needs beneficiary later down the road.
It seems like sometimes they don't have what's called a residuary clause, where they don't say, and the rest of it goes over here.
Right. They might say I give us a few certain items away, but then what's left has to go somewhere. And then you end up like that one with the 50 heirs, and you can have a will with a partial intestacy, so you still have to have the heirs determined by law. So it can be a mess, and people see things on TV, and they like to write in things too. Like they can make things a lot more complicated than they need to be. I had one recently where he didn't want anything to go to his nephews, and it was one of those cases where there was no residuary clause, so it was going to go by heirship law for the remaining whatever's left besides the specific things he listed out. Would go by intestacy law, and actually by intestacy law, his nephews wouldn't have gotten anything, just the structure of his family. They were not actually heirs, but by naming them, he gave them each $1. Just to point out, because he probably heard that you want to make sure that it's clear that you're intending to disinherit them.
And you don't have to leave people $1, do you, Ann?
No, and it's bad because he didn't have those magic words. So we wanted everyone that takes under the will to agree to an independent administration, but he didn't even know where these nephews were. And you'd have to prove that they got their $1, but they might not sign a receipt for $1.
Right.
They might not cash a $1 check. And so he could get stuck with a dependent administration when they really wouldn't have gotten anything anyway. So
Again, don't try this at home.
Exactly.
All right. Go to our website, texastrustlaw.com. We have Ann's book, Surviving Texas Probate, right here. We've got 3 other books up there. We've got the Texas Estate Planning Handbook. We have the Texas Asset Protection Handbook. We have Estate Planning for Women. You can download them all. You can go to Amazon and order this book off at Amazon too. This is complex stuff. It seems simple, and people get angry sometimes. Well, why is it then simpler? And it's not simpler because there is so much fraud out there, and identity theft out there, and unscrupulous family members, and now not even family members. My girlfriend, my boyfriend, my partner, somebody I met in the grocery store, somebody I met online, and they all want your money. And if this isn't handled carefully, the court can't determine all this, and you screwed it up inadvertently, or really know you don't have a will, then this is going to be complex stuff. It's going to be expensive stuff, and don't be an idiot.
I think the best thing, one of the best gifts you can give your family is to get your planning in order to make your administration as easy as possible, because your family's going to be grieving anyway, and the last thing they want to deal with are all these little technical legal details. So if you can get it all smoothed out ahead of time to make it the easiest process, it's just really a gift.
And anger is one of the phases of grief, and you don't want to die and have your family angry at you because you screwed this up. So don't screw it up. You can contact the Wiewel Law Firm at info@texastrustlaw.com. We set appointments for people all the time. But again, if you need help with this, get help with this. Get an experienced estate planning lawyer to help you with this. But get it done, and get it done like now. All right? So thanks for listening. Thanks for watching. If you're watching our video feed on this, I want to thank Ann Lumley. Ann is the absolute best estate administration lawyer on the planet. And she's very smart. She's very nice. And she deals with people that are grieving all the time. And so we can help. Let us know. But thank you very much for listening. Thank you very much for watching. Have a great day.